My question is basically that, say, my client has given me instructions to sue a company, and then the defendant, the company, chooses now to, the company chooses to pay the money through me, to pay my client through me, but the money supposed to be given to the client doesn't go to the client. How does that operate?
What's your name?
Sam.
So I don't know how you want us to go about it. We take questions and then
we can just react to that one as I'm waiting for people to raise their hands.
Okay. Now, second point is, what did you agree with your client? Because again, when you're doing a demand, for example, the demand should be able to include the bank details where the money is supposed to be remitted. And that demand, again, you are supposed, good practice, to CC to your client. Now, if the client does not have a problem of the money being paid through you, you therefore, as an advocate, cannot deduct your fees in the absence of either an express or implied agreement between yourself and your client. So again, it's important to go back to the drawing board with your client and agree on the fees to be paid. So you cannot deduct your money from that. It's professionally not sound.
Thank you, Senior. There's someone whose mic is unmuted. Please kindly mute your mic. I'm not sure it is. But meanwhile, we can take another question.
Sam, is that clear?
Sam? Thank you. Mr. Sam?
That's quite in order. Thank you so much.
Okay, thank you, Sam.
I also have one question, Mr. Diro. Now, there is a practice I've seen in law firms, especially when we are perfecting securities, where firms finance the perfection process, and then to recover once the perfection process is done. Do you think whether this is a proper practice, where law firms use their own money and then they would recover after the perfection process
again
is done?
Yes. Again, what's your name?
This is Nyamumbos.
Okay. Now, you see, everything again goes back to the agreement that you have between yourself and your client. If you agree that once the money has been released by the financing entity, do they release less to your client less your fees? And the fees would mean that you have raised your invoice, and the invoice should be able to capture any expenses that may have been incurred by your law firm. So whether it is good practice or not good practice, it is happening, and it depends on how you have agreed with your client. And of course, the financing authority must be informed beforehand and before they release the monies.
Any other question? Feel free to interject and just ask your question.
Does that answer you, Mr. Nyamumbo?
I believe so to some extent, though I was of a different opinion. I don't, despite it being an agreement between parties, I don't think it's proper practice. We would find ourselves in a similar situation as your client, Caliph Cairo.
For the record. Okay. You see, but it's more of a champate agreement, which of course we all know it's illegal. But these things are happening in law firms because the person borrowing the money does not have the money at as at the moment that they're borrowing the money. What they have is an asset, a security. So what they do, they say, once the money has been released to me, then I'll pay you. But you can have a side agreement with the financial institution and say that before you release the money, make sure that my money is paid up to me.
I have a question, and it's with something that you have deliberately not addressed, which is of billing. Technically, the statutes provide that undercutting is an offense.
Yes.
So there's nothing like overcharging. So with that in mind, a sole practitioner of at least maybe less than 5 years experience, what would you advise them when it comes to billing? What are the key factors that they need to consider?
Again, we go back to the mentorship issue, because look, the legal profession currently, the numbers are blotting. There's competition, that a client walks to a law firm and says, this is the much I can pay. Then it is discussed amongst the partners or amongst the associates, and they say, no, this is too low. Then we move to the next law firm, which is always next door. And that law firm will take it up. That is undercutting, because we are guided by the Advocates Remuneration Order. If that advocate takes up the matter, they will proceed and execute the instructions successfully. So whether you took it or not, somebody else is going to take it. So this is where we are finding ourselves, that the competition has grown to a point where professionalism is oftentimes, just brushed away. Yeah.
Okay. Any other person with a question? There's something senior that you said we hadn't addressed when the call accidentally dropped. Would you like to address it right now?
The one for McCarry and Success?
Yes.
McCarry and Success is, you see, it's the same thing. Let me just talk about McCarry. McCarry is the pride.
Yes.
The pride that we found with Makerere. When you go to Makerere, you are taught how to behave, courtroom mannerisms, client management. These are mandatory topics at Makerere. The success is because we are deliberate in what we do. We are also taught patience. Build your practice patiently. So long as you have an identity in the profession, people will troop to you. So it is something that you find somebody who went to Alliance, same thing. They identify with the success. Somebody who went to MANG, somebody who went to Harvard. So it is something that the culture over the years nurtures you to behave in a certain way. In every law firm setup, there's a lots and lots of money. If you're not able to differentiate between client money and your own money, then it becomes very difficult for you to have financial discipline. A client will deposit, for example, 30 million in your account. Then somebody in a Porsche drives through and you admire the car. But since you have 30 million in your account, you'll call your car dealer and ask, how much is a Porsche? They'll tell you Porsche is, say, 10, 15 million. Since you have 30 million in the account, what is 15 million? So you'll take the 15 million, wire into the car dealer account, and then you have a car. Thinking that you're going to recoup this money within a short period of time. Then the client calls for his money. Rushing to make money is not a bad thing. if you have financial discipline. So you find somebody, money has been paid, they utilize the money on luxury, and then the money they were expecting to come, or the client who had promised them a brief, does not bring the brief as had been instructed. So you find this lawyer now goes into depression, and depression is something that is actually killing most lawyers. It is a very sad state of affairs, which LSK again needs to address. Now, a law firm should be able to have 3 accounts: the client account, the firm account, and the operating account. Of course, the managing partner should have his own personal account. So operating account is just to pay for the expenses, the daily expenses, milk, bread, or the stationery that is needed, electricity needs to be paid. Then there's that one for salaries, because again, you fall back on salaries, they become demoralized. And of course, now there's a client account. A client is purchasing a property, deposits 100 million in your account. That has never been your money. Your fees will go into the firm account. The moment you look at your account and you see 100 million and you think you have money, you walk around like a millionaire, that is where we start going wrong as advocates. So that's why mentorship is very important. Rushing to open your law firm before you're ready has never worked. You will actually just stay there, stagnate. Then you find yourself getting involved in some very funny businesses. Yeah.
Thank you very much, Mr. Dero. So I found myself smiling enough times in this conversation, because a lot of the things that today we've shared are very relatable, whether it is the commingling of accounts or it's the aspect of not having proper structures, because it's about starting right. When it begins wrong, it ends wrongly, and we are trying to build sustainable practices within this industry. Allow me to take this opportunity in the interest of time to first of all thank Mr. George Okenyo for convening and hosting this particular conversation. Thank you so much, Senior, from wherever you are. I know you're on the call.
I forgot, you live within your means.
Oh yes, so he is saying live within your means, and we are getting there. Importantly so, Mr. Okenyo, thank you so much. Mr. Dero, screaming here, live within your means. Do not let the success of other lawyers be what will intimidate you. And I think that's something he has consistently said throughout the conversation. A day at a time, a step at a time. Your journey is different from the next person, and we've learned about mommy and daddy lawyers. So when you're thinking that I started my law firm it's an OB firm, Onyalobiro farm, and I am thinking, oh my god, I'm stuck in town, and you're hearing someone is in Westlands, Kilimani, Mombasa Road with posh seats from Furniture Palace as the one we're seated on, and they're very expensive. Try and understand the journey of those people, because they started from somewhere, or they have someone somewhere who's sustaining the same, and your journey is different, importantly, and do not bow down to peer pressure. Thank you, Mr. Dero, for hosting us in your very beautiful office. Thank you for the words of wisdom. Thank you for sharing your time. I know today was a day that you had so many things planned, so sacrificing this time, we're most grateful for that. And thank you for opening up your entire team to assist us. To the team behind the scenes that you'll never get to see, but they're trying to ensure things run, to some who I'm staring right at. So normally when we run these conversations, we record the same, so we have a set that we've organized. All these particular recordings, you'll find them on George Okenyo Omwansa's YouTube page, Okenyo Omwansa. For the first conversation, which I moderated and he was a speaker, when we speak about policy, it's already been updated and it's been broken down into small chunks, so you don't have to feel it's overwhelming. Same to Mimi Aldrin's particular recording, it's already been uploaded. That was on work-life balance, and this particular one will be uploaded in the next couple of days. As we're working on our teething problems, we shall continue to try and be sustainable and operate within our means. But thank you so much to the audience for ensuring that you've consistently showed up for this conversation. You've mined from wisdom of our elders. I am a Gen Z, so I get to say elders, not ancestors, but elders. And thank you so much. For those of us who will meet in the profession, please, please, please feel free to say hi. That is how we network, and that's how your next brief comes. It is as near as the next person within the profession that you get to say hi to. Thank you very much for your time, and allow me to release you at this point. Have a lovely, lovely, lovely week. Thank you.